Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, your trusted 360 General Counsel, and this is a note from my Legalpad. So this is part 3 in our 3-part series on how to have your legal house in order. Because remember, our goal is if we stay ready, we don't have to get ready. So we're talking about the 3 C's. And so we've discussed corporate governance, we've discussed contractual rights and obligations, and now we're going to talk about claim mitigation, limiting liability. So when we're looking at claim mitigation, we're going to look at it from 2 perspectives. One, limiting the ability of others to make claims against your business, and then protecting your rights and your business's rights to have claims against others. So one of the first places that you deal with claim mitigation is in your contracts and in your terms of service with the public or with your vendors, with your employees. So you can do this in a couple ways. Master contracts for services, master employment agreements, or also terms of service, and making sure that they have some key provisions that are in there. One, in order to secure your rights, you want to make sure that there are provisions for interest and late fees if you have customers that are paying you kind of in arrears for your services or your goods. 2, if you are providing services and goods to others, you want to have provisions that limit your liability. That basically means that regardless of what happens in the nature of the relationship, if there is a dispute, that your potential monetary liability is set at a specific predetermined amount. There's a ceiling on it. That can be a specific dollar amount, it can be the value of a contract, it can be tied to your insurance coverage, or any other number that the parties are able to agree on. Third, another piece for claim either mitigation or being prepared for claims is making sure that you have a contractual provision that gives you a right to recover your attorney's fees and costs if there is a dispute. That can be arbitration fees, that can be litigation fees, and court costs. That is very critical provision to have in your contractual documents in order to mitigate the damage caused by a claim being brought against you or you needing to assert a claim against another. Once you've got your language right, then you'll want to evaluate the universe of potential claims that may be out there with regards to your business. That means if you've had incidents that you have notice of where a customer had an issue, there was a dispute with an employee or a vendor or a competitor, that you have some documentation where you are detailing some of the background of that dispute, the potential value of that dispute, and whether or not the dispute has an opportunity to be resolved or settled. You'll want to have waivers and releases as another thing that you put in your arsenal to resolve disputes or to limit liability that may be associated with a dispute. Waivers are something that can come at the beginning of the relationship with a customer or vendor, but they can also come on the back end of a relationship if you are resolving a dispute and you want to, each side agrees to release any additional claims that may be out there. You can also look at your potential claims, both that you may have or that may be had against you, and make sure that you have insurance coverage for those items and for your business, for your goods, for just your activity in general in the world. And your insurance can both cover claims that are brought for actions that you've taken or losses that may come against you for an injury that comes to your business. So you want to look at your insurance coverages. Another thing that you can do when you are auditing potential claims is deciding whether or not to set aside some reserve funds that can be utilized to resolve claims, or if you know that there's a claim out there that could be expensive down the road, setting aside a defense fund, setting aside funds to settle that claim or to investigate a claim can be a great way to mitigate the impact of that claim. You want to be aware of the statute of limitations. The law has a time period in which a claim can be asserted. It can be anywhere from a year from the point of the injury, when there's a personal injury sort of claim, all the way to either 4 or 7 years for contractual disputes. And there are statute of limitations at various time periods within there. So you might want to be aware of how long someone has to bring a claim against your business, or how long you have to bring a claim against somebody else or another business that you may be in a dispute with. Once you've taken a survey of potential claims that are out there, then you'll want to make sure that you're preserving any relevant evidence. If it's a product issue, to whatever extent you can preserve the product, or document the product with either photographs or video. If there are communications, letters, emails, text, making sure that you're preserving those items as well. Another final area for claim mitigation that you'll want to be very clear on is the bottom line for your business, and that's the status of accounts payables and accounts receivable. Understanding how much do you owe out and how much is owed to your business, and how you're managing that cash flow and managing both your accounts receivables and your accounts payable. And that ties back to whether or not those cash flow items are being utilized to secure financing, or you're looking to utilize them in the future as collateral to secure financing. So you want to keep a manage on that inflow and outflow of cash. So these are some of the key things that you'll want to think about when you are mitigating claims in order to have your house in order so that we can stay ready and we don't have to get ready. If you'd like more information from the attorneys at Smithers and Ume-Nwagbo, you can go to our website at STU Law Group. You can find us on Facebook or LinkedIn. And this has been a note from our Legalpad.